I'm going to discuss with you the advantages of a living trust. Why do we need one? When do we not need one? It's very important that you think of this when you do your estate planning. So many people come to their lawyer and they say, I want a will. Well, a will is wonderful. It does tell the world who you want to have receive your assets, and it lets the probate court judge in a probate proceeding work with your probate attorney to have your goal of getting your assets to your loved one. But it's time consuming. It takes generally a year from beginning to end in the state of Wisconsin, and it can be expensive in that you have to have a probate attorney assist your loved ones to get your assets retitled. Now, generally that probate proceeding takes place at the death of the survivor of the husband and wife. Generally, when the husband dies, things avoid probate naturally because they're either in joint tenancy or they have a beneficiary designation. So that brings us to the question of, well, why do we need a living trust? We hear so much about them. Why do we need a living trust? Well, the goal with a living trust is to avoid the probate process through both the husband's death and the wife's death. As you heard earlier, you may not need it at the husband's death, but you will certainly need it at the wife's death. So, why does that happen? Well, at the husband's death, things that were in joint tenancy now end up being in the wife's name and the wife's name alone. Nor should they be in joint tenancy with a child. So, you end up with a probate asset, an asset in the wife's name alone that is not in joint tenancy and does not have a beneficiary designation on it. So you could say, well, why don't I just put beneficiary designations on everything? Well, that could work, and we do that many times, and we call that our probate avoidance package. And it doesn't have a living trust as part of the package. It just strictly is designed to avoid probate. But it's a simplified way to avoid probate. So we can't do things to be in a situation where we hold back money from a child who maybe is too young to get that money, 2, 4, 6, or 8, or maybe too financially immature on how to handle a large sum of money. And that might be the 24-year-old, the 26-year-old. So there are sometimes reasons why the people coming into our office, our clients, want to hold money back from a child until they're older. Have somebody else manage the money for them. Have somebody else determine what their needs are. Not what their wants are, but to determine what their needs are. And when you have that scenario, the best solution for that is a living trust. Now, trust could be set up by the probate court judge by just putting words inside your will. But that has more expenses associated with it because you're going to end up in probate court. And then you may have continuing court supervision over this trust set up by the probate court judge. So a living trust is a document you set up during lifetime. You may not put any significant assets into it, but it's there so at your death it can be administered without the need to be involved with probate court. So we get both our probate court avoidance and we get our hold back the money from young people, and we get who should this money go to. So now, when do we not need the living trust? Well, maybe I don't have a goal of holding money back from my children, and they're maybe in their 30s, 40s, or 50s, and I know how well they can handle money. And so at my death, if they get more money, I know they can handle it well, so I don't need to hold it back from them. So I could do an outright distribution. Well, I could do that in a trust, but I could also do that by simply using beneficiary designations. Things we're familiar with already. We put beneficiary designations on our life insurance to our children. We also put beneficiary designations to our children on our retirement plans. However, if you listen to our video on the IRA trust, that'll explain to you why that is no longer a good decision. Instead, the money should be payable into an IRA trust, a very specialized trust, separate from your living trust that you would have as part of your estate plan, and a method to stop the creditors of your kids from grabbing your IRA at your death and using it to pay off your kids' bills. And the main bill I'm concerned with is the $10 million judgment that is entered against your child because the child caused an auto accident and hurt somebody severely and has a judgment entered against them. So that's a reason not to name your children directly on your IRA or other retirement plan assets. So just keep that in mind, and for more information on that, you can listen to the video that we have on the IRA trust. But now let's say that you're just talking about life insurance. You could have that go to your children equally. You could also do the same thing as a widow on your checking and savings account. And in Wisconsin, with advice, you could do it even on your real estate. Also in Wisconsin, we can take advantage of something that's pretty unique to Wisconsin that may not be available in any of the other states except those states that have community property or marital property. And that is, we can have an agreement signed by husband and wife to make probate assets not probate assets, so that we can distribute them without the need to spend the year in probate court. So that could be another way in which we distribute assets. So let's review. We could have the beneficiary designation go directly to the kids, except for the IRAs. We could have the living trust be the beneficiary and thus hold money back from kids if that's our goal. We could even handle the fact that we don't want to give money to a child because the child is on government benefits, maybe a special needs child, and we don't want that child to lose the government benefits that the child is on. And so that's solved with a living trust, which has a special needs trust built into it. So there's lots of reasons why you'd want to use a living trust. So we would encourage you to get more information about this by calling our office at 262-634-6659, where we could discuss with you the advantages of a living trust and when you might be able to get by without needing a living trust. I thank you. Hopefully you found this helpful.